everyone. Thank you for joining another casework stream. We're joined again by Richard Meadow from the Lanier Law Firm. Rick, thank you so much for joining again. The last time you and I were on the stream, we're talking about the same thing, and it was all things talc. And so, very different conversation today, and just wanting to understand what in the world is going on. Lots of questions are coming our way, and I wanted to reach out to you, one of the experts in the industry, and just get some insight updates and just the skinny on what is going on with this new order.
My pleasure, and thanks again, Susan. I always enjoy being with you, and now your brother too. I like seeing Bill around. Last week, I believe it was last week, the Third Circuit handed down an opinion which dismissed J&J's bankruptcy. It had been upheld in the trial court on 2 separate occasions, went up to the Third Circuit, and the Third Circuit, in a 56-page decision, just took the bankruptcy apart. I mean, there were some real nuggets in that, such as absent financial distress. There's no reason for a Chapter 11. You can't go into Chapter 11 to protect your name when you have enough assets behind you to continue on. And before we got on this call, I did today's market cap of J&J, which today was over $432 billion market cap. It's the 16th largest corporation in the world. And then with over $30 billion cash on hand. So this is a company that's very, very solvent and lucrative, and had no reason other than trying to avoid liability to go into bankruptcy. In addition, in 2020 and 2021, they distributed $13 billion in each year to their shareholders. So there's cash there. And they tried to make use of, unfortunately, it's called the Texas two-step, where a corporation takes all its liabilities and puts it into one company, keeps the good company, how they use that, a good company, in quotes, with all the assets, puts all the liabilities in one corporation, and then bankrupts that new corporation. They filed the new corporation in Texas, and then they took that corporation to North Carolina, which has very favorable bankruptcy laws, bankrupted that corporation. And fortunately, it was moved up to New Jersey, where the MDL is located, and where it went through the trial process, went to the Third Circuit. And here we are now, the final order saying the bankruptcy is dismissed, the stay is lifted, and all systems are go in plaintiff world.
Well, so what does that mean for firms like yourself? The last time we were talking, firms had been reaching out, even against your, we had talked about this on the last stream, is like, just because the stay is in place, don't stop working up your cases. Don't stop the client communication because you had, belief that exactly what's happening today was going to happen, but that wasn't the case. I know a lot of firms did just cease work, and so those cases have been stagnant and sitting. So what are your suggestions, and what does that mean now for firms that have this large docket of talc that have been sitting over the last however many months?
If you've been working up your cases, kudos to you, because even if it had stayed in bankruptcy, you need to still work up those cases, because there would have been a resolution coming out of the bankruptcy court. So you should have continued. If you have not, if you haven't worked up your cases, now's the time to do it, because the deadlines will be back in place, probably, adding the months on that we were in bankruptcy court, and the discovery will continue. The trial should be scheduled, and possibly, there may be a lot of clients or firms looking for remands of their cases. So you mean, treat it like there was never a bankruptcy right now. Just start litigating your cases. They're going to have to come to the table now, you would think. With trials impending and a remand, there's a new judge assigned yesterday, Judge Shipp, I think his name is Michael Shipp, because Judge Wolfson retired from the bench. So bottom line is, work up your cases, get your medical records, do it as if there was never a bankruptcy, and you're litigating right now.
You mentioned, yeah, that's great advice. And I'm sure our top team is standing ready, excited to have heard of this news. They're ready to push forward and start helping the firms again, continue their case development, pick up where we left off.
Right.
And then our team that helps to keep the clients engaged throughout the process is ready to get to work as well. But you mentioned some other great nuggets in that 56-page document. Anything else that you would want to highlight?
Well, they went through, they just tore apart every argument that J&J made. They talked about good faith and said good intentions do not make good faith. When you have a solvent backer of a company, LTL, which is what went bankrupt. When you have a solvent company behind it that can easily and adequately fund any sort of liabilities, there's no reason to go to bankruptcy court. That is not where you resolve disputes when you're able to resolve them. It's different than some of those old asbestos companies, which had limited resources, limited assets, and tremendous liabilities. And the Texas two-step was created for some of those asbestos companies. Right now, J&J, the court points out in so many different situations, and that there is adequate resources from the J&J parent company, that they should never have been in bankruptcy. They didn't come right out and say it was a fraudulent bankruptcy, but they used the word good faith a few times and unintended, and they went as far to the line with calling it a fraudulent bankruptcy as I've seen a court do.
Well, I think too, folks were scared. Would this set the stage for other offenders to follow in their footsteps?
That was a big concern, and we discussed that a lot at the firm. I mean, you have all the major corporations, all the major pharmaceutical corporations, Pfizer, Merck, Sanofi, GlaxoSmithKline, all probably watching this very carefully. And when you see that the court just really took apart this bankruptcy, I think it'll discourage them. I mean, bankruptcy court was not created for the solvent. It was created for the firms that are in financial distress. And obviously, J&J is not in financial distress.
Well, Rick, I certainly appreciate you taking time once again to talk all things talc. I know that if attorneys are looking to restart their case development, Caseworks is here to help. And also, if they're looking to find a home for those cases, you're certainly one that would love to talk to them about.
Yeah, we are accepting cases that have a little bit of a workup, have the HIPAA signed, the retainer signed, and confirming medicals for ovarian cancer. We definitely would look at people's inventories to put into a settlement. So you send it my way. No problem.
Yeah, absolutely. Awesome. Okay. Well, thanks so much for sharing this news. I really appreciate it. And
see you soon.
we'll see you soon.
Okay. Take care. Bye-bye.
Okay.